Well, good evening and welcome. I'm Robert Litvak, the Wilson Center's Senior Vice President, and I extend a warm welcome to all on behalf of our President and CEO, former Congresswoman Jane Harman. This year, the Wilson Center is celebrating the 50th anniversary of our establishment by Congress as a living memorial to our 28th President. Through our residential fellowships, meetings, and publications, the Center seeks to provide policymakers with the analytical tools to improve decision-making. We're delighted to be partnering with the International Bar Association on this event. The IBA is the world's leading international organization of legal practitioners, bar associations, and law societies, influencing the development of international law reform and shaping the future of the legal profession throughout the world. Indeed, it is very impressive that the IBA has member lawyers and societies in more than 160 countries. The Wilson Center was recently named the #1 regional think tank in the world by the University of Pennsylvania's annual survey. Rule of law is an issue that cuts across all of the Wilson Center's 11 regional and country-specific programs.
You can have a glass of
and it's a
water
topic
because they only have two.
on
I
which
brought
we
my
intend
bottle.
to
Oh, you have
intensify
one.
our work. Tonight's topic, preserving a free society, governmental power, and the rule of law, is timely and important. We look forward to hearing from our illustrious speakers, leaders in different branches of government and law from both Republican and Democratic administrations. With that, it is my pleasure to turn the floor over to tonight's moderator, Homer Moyer. Thank you.
Rob, thank you, and thanks to the Woodrow Wilson Center for providing the venue for today's event. On behalf of the International Bar Association, it's my pleasure to welcome all of you to Preserving a Free Society, a series of programs discussing the rule of law and the role that the rule of law plays in helping maintain and sustain free and open societies. My name is Homer Moyer. It's my privilege to host this series of discussions. And for today's discussion on governmental power and the rule of law, we are delighted to have three very distinguished guests. Each has served as a senior official in our government, and together their experiences span all three of our branches of government. And as it happens, they also have diverse geographical roots, hailing respectively from Maine and California and Virginia. To my immediate left, Senator George Mitchell served as the Democratic senator from Maine for 15 years, 6 of which he served as the majority leader of the Senate. He was also the United States Special Envoy to Northern Ireland and Special Envoy for Middle East Peace. Two daunting but flattering assignments, I might say. Ambassador Carla Hills has held 2 cabinet posts in Republican administrations. First as the Secretary of the Department of Housing and Urban Development, HUD, and in the first Bush administration as the United States Trade Representative. Third, Judge Tom Griffith is a judge on the U.S. Court of Appeals for the District of Columbia, appointed by President George W. Bush. He is currently a sitting judge on that court, and before that served as the Chief Legal Officer of the United States Senate. So we thank all of you for joining us today. One housekeeping matter: during our discussion, we will not be taking live questions from the audience, but cards are available to you, and if you have a question, write it on a card, pass it to the end of the row. Michael Maya will collect them, and we'll have 2 or 3 questions for our guests at the end of our discussion. As this is a conversation about the rule of law, it seems appropriate to start with that phrase, the rule of law. What do we mean by the rule of law? This is a term that has been defined in many different ways. Some countries purport to embrace the rule of law, but define it in terms quite differently. from the way that we might define it. But as a starting point, let me table the following definition and then ask our guests to comment on it. The term rule of law is a shorthand phrase. It's a composite. It is shorthand for a number of basic principles of governance that may or may not be accepted or committed to by different countries. And among the principles most commonly cited are these. First, that the powers of government are separated. They're not concentrated in a single person or a single authority. Second, that the judiciary is independent and impartial. That the laws are accessible and are adopted in a transparent and open fashion. That the laws apply equally to all persons and, importantly, apply equally to the government itself, which is also bound by the law. That the laws protect fundamental rights and dignity of all persons. And finally, that as public servants, government officials are not corrupt. So with that, let me ask, and Senator Mitchell, I'd like to start with you. Is this a fair definition? How would you modify or elaborate on that?
I think it is a fair definition on its own. I would suggest sharpening the provision which refers to the government itself being bound by the law to include a reference specifically to the ruler or leader of government. Throughout human history, for much of the time, until just few hundred years ago, rulers were by definition exempt from the law. We all think back to the Magna Carta about 800 years ago, in which the English barons first imposed upon the King of England what I would call the principle of restraint on or limitations on the power of the king. That's been hotly contested over years. The Magna Carta has been defined and in many different ways, but I think that principle is important, and I think it continues to be relevant in today's world. You can see around the world where leaders are essentially exempt from the rule of law, are able to impose their will on society and are exempt themselves from the very provisions. And even in what have been recently democratic societies, there are trends in that direction.
Ambassador Hills, let me ask you if any of those principles stands out to you as particularly important.
Well, I think that they're all important, but let me first say that I would make changes in two of them. Your third, the law is accessible and are enacted openly and transparently. I think I would say the laws are prospective, that is looking forward, and accessible to all persons, not just specifically accessible to all persons, enacted openly and transparently. So minor changes. But then my second change is more basic. You know, when they talk about rule of law, they say those people who believe in a formal rule of law and those who believe in a substantive rule of law. And the fifth one that you recited was that the laws protect the fundamental rights and dignities of all persons. And that is a substantive statement of a rule of law. Since I'm interested in having other countries buy aboard the concept of rule of law, I'm more of on the side of those who are on the formal. And I would edit that to say that the laws protect the security and safety of all persons and their property, and not load up rule of law with fundamental rights and dignity. because my experience is that different countries regard fundamental rights quite differently. And that means that they would be likely to say no thanks if there's not a definition of the fundamental law that they adhere to. I think that the basic notion is people should know what their rights are and what the government intends to do in terms of imposing burdens or bestowing benefits. So, and I would also point out that in our country, we debate what our fundamental rights are. Do you have a fundamental right to abortion? Do you have a fundamental right to bear arms? I mean, we could argue that the Second Amendment was dealing with militias, not with individuals. But could we get a consensus? And so is that a fundamental right? It makes a debate, and I'd like to see us instead stand up for rule of law without the substantive debate. Leave the substantive debate for the second point of the meeting.
Good. Happily, we don't have to resolve some of those issues tonight. Judge Griffith, your perspective.
Yeah, the only thing I would add to these excellent comments is that one way you can tell if the rule of law is working is if the strong don't always win, right? That there's a sense that it's the law that governs, and sometimes the strong are going to win, sometimes they're going to lose, and if that isn't happening, then you probably don't have the rule of law. That, to me, the most fundamental concept of the rule of law, it can be reduced to this: that might does not make right, and that there are protections, so that sometimes the weak win, sometimes the little guy wins, sometimes the big guy wins. But
many of these principles that you've just been talking about are embedded in our national blueprint, our Constitution. Ambassador Hills, is it right to think about those as sort of national values, as fundamental tenets of our society?
We certainly, as Americans, can laud them in that fashion, but others outside our borders may not see them in the same fashion as do we.
Senator, when the drafters of our Constitution put these principles into that document, they did that for a reason. Winding the clock back a bit, what were some of the concerns? What prompted this? What were some of the evils that these principles are designed to guard against?
They had lived under a British king, and they did not want there ever to be an American king. And whatever else you may say about them, they were brilliantly successful in that regard. We have never had an American king. And there were many other objectives, of course. They wanted to decentralize power. They were conscious of both the strengths and the weaknesses of all human beings. I found this comment from this statement by Jefferson on the question of how tightly should be controlled the actions of government leaders. He said, in questions of power, let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution. Adams said, and as many others did, we're a nation of laws, not of men. And so I think, and Monroe was, of course, very active at the time, and others, they were concerned that even the best of men, now we would say the best of men and women, are fallible, prone to the abuse of power. They didn't say, I'll say, that they recognize the almost unlimited capacity for rationalization that human beings have, particularly those who get some degree of power or control over others. And so they wanted to make certain that no person, no branch of government, no agency achieved total power. And they, of course, they wouldn't recognize our government today because they regarded the House of Representatives as the central repository of power and protection of the liberties of Americans, did not give the presidency or the Senate the primary roles that they have now.
One of the ways that the framers sought to prevent governmental abuses, of course, was by separating the powers of government. We have the luxury of having guests that have served in all of those branches. So let's talk about this idea, the idea of separating governmental power and of creating a system of mutual checks and balances. And Judge Griffith, let's start with the judiciary. Alexander Hamilton in the Federalist Papers described the judiciary as by far the weakest of the three branches of the government. Yet it is the courts and the judiciary that have the primary responsibility for the obligation that Senator Mitchell mentioned, namely making sure that the government itself does not overstep its bounds and exceed its legal authority. The court on which you sit and the Supreme Court probably get more cases than anywhere else in the country involving this question. Has the government exceeded its legal authority and gone beyond its power? So let me ask you, sitting where you do, what is it like to have that responsibility and to make those types of decisions?
Sure. Well, first of all, let me put a caveat on this. It is true that the courts have a responsibility to make certain that the other branches of government don't exceed their powers, but that's also a responsibility each of the branches has for themselves. Every officer in the executive branch, every member of the Congress takes an oath to uphold the Constitution. And there are some questions, interbranch questions about whether the executive has power X or whether the Congress has power Y, that are to be resolved just between the political branches themselves. The courts have no role in them. So there is a responsibility there by every person who takes the oath to uphold the Constitution to make certain that they don't exceed their authority and to hold the other branch in check. But there are certain category of cases that it does fall to the courts to decide. It is an awesome responsibility, and it's one that the judiciary should take seriously, I think does take seriously. There's probably no more serious act that the judiciary can undertake than to say to the political representatives of we the people that they've done something amiss. I mean, let's remember that the primary liberty that the Constitution recognizes, the most fundamental liberty, is the right of we the people to create the laws by which society is governed. And when the courts step in and say they've exceeded that power because they violated the Constitution, that's an awesome act that should only be done carefully, and in my view, only when it's clear that the Congress or the President has exceeded its responsibility. So one way to illustrate this, we all remember back in high school civics, there was a cartoon, it's now a video of how a bill becomes a law. And it's a nice little explanation of how we make law under the Constitution. As far as I can recall, there was never a picture of a judge in that. Judges are not there to make law. They're there to enforce the law. And so they need to be very careful. We need to be very careful when we say the lawmakers have gone beyond their bounds. That's a remarkable power.
In our country and in your court and the Supreme Court, we nonetheless see quite a few cases raising this question of the government's power. And that's one of several principles that we talked about and that the Senator emphasized. So as a country, how are we doing with that component of making sure, of holding the government's feet to the fire and making sure that it does not exceed its authority?
Well, I think maybe that's a self-serving comment, but I think I think about a recent example we're all familiar with in the wake of the 9/11 terrorist attacks. The president and Congress determined that they were going to detain alien combatants, foreign combatants at Guantanamo Bay under a certain set of procedures. The courts stepped in, the Supreme Court stepped in and said, that's inadequate what you're doing. It violates the right of habeas corpus. And in an exercise of deference and comity, the executive and the Congress responded. So that's extraordinary. That's a wartime power of the president and Congress. In many ways, that's the apogee of their power. And yet the Supreme Court stepped in and said, you have crossed a line, and they complied. With whether one agrees or disagrees with the Supreme Court's analysis, I think it was a pretty striking and recent example of how that power works.
Senator.
I believe that's one of the central features of the American system that represents our dealing with an issue that makes it difficult for democracy to take root in very large parts of the world. And that is the tension between what I think of as the two pillars of democracy: the sovereignty of the people, expressed through open and fair elections, and power given to those who win elections. But at the same time, restraints on that power by granting to every individual certain inalienable rights that are expressed in our Bill of Rights. That's a very difficult thing to do. One of the reasons democracy is having such a hard time gaining roots and a foothold in portions of Asia, the Middle East, and Africa is that their customs are, if you win an election, you're in, and if you lose, you're out, or you're in prison, or you're dead. That is, the rights of minorities are not fairly recognized and protected in many societies that purport to be democracies, and that's one of the reasons why the system don't function. Now, we still wrestle with it here, as Judge indicated. It's a very difficult question, hard to resolve individual cases. But your question to Judge Griffith was, how are we doing? I think we're doing very well as a country. And in particular, this is a very big country, 330 million people, covering a huge continent, extremely diverse in comparison with others. The United States is unique in many respects, not least of which is most nations formed around relatively homogeneous groups based on religion, ethnicity, language. Our country is formed around ideals.
Some of which are pretty ambitious.
They're very ambitious, but that's why we're successful. That's why this remains, in my judgment, still the most open and most free and most just society in all of human history. Difficult as it seems at some times that we're wrestling with tough issues.
Ambassador Hills, the Constitution gives to the executive branch what some have called the power of the sword, presumably meaning the ability to take initiative and act decisively. At the same time, the executive branch is subject to checks and balances as well. I don't know if departments and agencies that you have headed have been subject to checks and balances, but what's it feel like to be checked or balanced, and how should officials respond to that?
It often leads to better policy. If I think of my days at the Housing and Urban Development, from about 1950 to 1970, the Chicago Housing Authority assigned people, low-income people, to certain redlined areas. In other words, they weren't going to be mixed in population, and they tended to not have models. And the Supreme Court ruled that the Chicago Housing Authority had to give tenants a choice of where they lived. Well, the first piece of legislation that President Ford, when he came in August of 1974, was to sign the Housing and Community Development Act, which gave vouchers. That meant the low-income people could rent, or they could go to the neighborhood that the Housing Authority had, but they were free to pick the neighborhood where they were to live. So I think that the three governments working together, judiciary, executive branch, and the Congress, can make 1 and 1 equal 3. And of course, in trade, it's indispensable.
Well, let me ask you about that, because international trade is one of those areas in which the bifurcations are not crisp and distinct. That's an area in which both the executive branch and the legislative branch have specified authority to act. That suggests a need for consultation, collaboration, compromise. In your experience, how has that worked and how should that work?
Well, let's talk about how it works and should work as one. Again, let me go back to President Ford, because he signed the Trade Act of 1974. And what that said was that we have a divided or separated form of government, where the executive branch has the power to negotiate with foreign governments, but the congressional branch has the power over tariffs, taxes, and financial matters. And so with the Trade Promotion Act, they worked out a system of consultation that was required. That is, if the president wants to negotiate an agreement, he must go to the Congress and say, I want to negotiate this agreement with this country. And Congress can say, well, what are your objectives? And the president can say, these are my objectives. And then the Congress can either give him that authority, vote and give him the authority under the Trade Promotion Act, or decline. If they decline, he may not negotiate. At least he can't on financial issues. If they give him the authority, then in return, the trade agreement that he comes home with after lots of consultation is either voted for or against without amendment. And that's the only way we would get a trade agreement, because if in our separated form of government, if a trade agreement is brought home and one single congressman is not in favor, it could hang a horrendous amendment on it, we wouldn't get the agreement through. This has lasted since '74. We've called it fast track, we've called it Trade Promotion Authority, but it really means that we've worked out the authority, the different authority between the executive branch to initiate and the congressional branch to approve.
Well, the subject of compromise, Senator, brings me to the legislative branch. One of the fascinating things, if you look back at the Constitutional Convention, it was all about compromise between large states, small states, how they should be represented, whether and how and when there should be a Bill of Rights. It is a product of compromise. Over the last perhaps generation, 20 or 25 years, the ability to compromise seems to have come on hard times in the Congress. Is this something we can get past? Is there a way forward to improve the ability to compromise, communicate, reach decisions on joint decisions on difficult issues?
Yes. I believe that one of the reasons for the lack of compromise has been the use of advanced technology in redrawing congressional district lines after each census. we've always had it. Elbridge Gerry was involved in the original documents in our country, and so gerrymandering isn't new. But it was for 220 of our 240 years of history, it was county lines, municipal lines, in large urban areas, ward lines. Now it's perfected to the point where you can move a congressman out of his district by changing his house, moving his house around. And it's gotten to the point where fewer than 50 of the seats in the House of Representatives are genuinely competitive as between the parties. Now the consequence of that is that the general election is no longer of any significance in the election to the House of Representatives. The crucial point in the process is the nominating process. And we all know that Americans' participation in elections generally is relatively low, and it's extremely low in nominating either primaries or conventions for the House of Representatives. Now, the people who tend to participate are the most active, the most intense, the most rigid, the most ideological. And so you have the spectacle now of about 50 Tea Party House members who have no general election worries. Their only fear is that someone further to the right than they are might run against them in the primary. And because of some of the rules adopted recently in the House, not written rules, just rules adopted by the majority, that you can't have a vote in the House of Representatives anymore unless a majority of the majority are for it. You can't bring it up even though it might be supported by the full House. Can't even have a vote on it. That's what happened with the immigration bill. We had an immigration bill 5 years ago that passed the Senate with a huge bipartisan vote, almost 80 votes. But the House wouldn't bring it up because the majority of the Republicans in the House weren't for it, even though if they had a vote, there would be a substantial majority for the bill. That's a huge problem. And until we now, I hope we can, modify the process by which redrawing of districts occurs to permit independent entities, courts possibly, other groups, that it won't remove the politics, but it'll drain it from it. And the second factor, I won't be as long on this one, is money has corrupted our political process. The American political process has been corrupted by the vast sums of money entering the political system, and paradoxically, just as the amount has increased, transparency has all but vanished. There is not a person in our country today who knows where the billions of dollars that went into the last presidential campaign came from or went to. And when I say it's corrupted, I don't mean in the sense of, you know, Senator Hills, if you vote my way, I'll give you a bag full of cash. Fortunately, that happens rarely in our society. It's much more subtle than that. What I do mean is that the confidence of the American people in their elected representatives has been severed. I ask audiences all over the country, how many believe that their elected representatives are more responsive to their constituents than they are to their donors? And in 10 years of doing this, only 2 or 3 people have raised their hands. And the first time it happened was in the suburbs of Washington. When I asked it and a woman raised her hand, I was so surprised I didn't say anything. But after the meeting, I went over to her and I said, I have to ask you, you're the only person in America who's ever raised your hand and answered that question. So I have to ask you why. She said, oh, it's very simple. My husband's a member of Congress.
That took care of that.
So let me ask you this, just how serious this problem is. There's a recent popular book entitled How Democracies Die. And the authors of that book suggest that political polarization is a great threat to democracy and the rule of law. Does it rise to that level at this point, or could it?
Oh, I think definitely. Definitely it could. We are not immune from the problems that ail societies and democracies. We've made plenty of mistakes in our country's history, and we'll make many more, but that is a huge challenge in our country. I believe it is a real threat to our democracy. We now have really two alternative worlds in our country in terms of not just what's right and wrong, but what are the facts. And I think that's a very dangerous thing for democracy.
What you in the audience may not know is that each of our three guests has in fact served in at least two different branches of government. So in terms of checks and balances, they're sort of politically bilingual. So let me ask this question. Checks and balances really mean that this business of consulting and compromising and collaborating is sort of built into all of the job descriptions of serving in government. And in my experience, people who come into government from the private sector sometimes have a hard time with this. It's a different decision-making model. Ambassador Hills, what's the right way to think about this different model and getting decisions done this way in our government?
If you're going to take a position in the cabinet and you are going to be confirmed by the Senate and you're going to have to get your measures approved in the future, I think it's important that you create a regular consultation mechanism. We certainly did that with respect to trade. If I didn't want the details of the particular negotiation to be widespread, we would ask for it to be an executive session. But I had an opposition party, House and Senate, in both roles that I held, and they were among my best friends. When I look back on people who helped us get things done, they were Democrats. And it's changed a lot, and I totally agree with what the senator had to say. The problem today is we don't, two problems I see. One is the members of our legislative branch don't know each other. They don't spend time together, they don't live next door to each other, they don't carpool their kids to school. This happened 25 years ago. And the other thing that is, I think, quite a problem is that we're not informing the American people about the policy issues pro and con. The campaigns have become sort of, I don't like you and you don't like me. And I want them to talk about what is your trade policy? What is your tax policy? What is your immigration policy? I want to know the policy. And I don't think in the past several elections that we've gotten that kind of thing. To the contrary, I think that we have misinformed the American public, that they've been told trade is bad. Never mind the economists say that by opening our markets since World War II, our GDP is $2 trillion better. I mean, you can go through the facts so that people understand that, and we haven't done that. And we also haven't done for those that have not been benefited by the increase in our economy from various policies, tried to help those and bring them upscale to the jobs that they could have and make more money. So training, handling our human infrastructure is worse than the way we handle our potholes and physical infrastructure. We need to change that.
I just want to say that
Sure.
I agree with Carla. One of the destructive national myths in our society today, propounded by both parties in the last presidential campaign, is that every job lost in America is the result of a trade agreement. Of course, there are some jobs lost as a result of trade agreements. That's inevitable. But the vast majority of job losses in our society are the consequence of dynamic innovation in a free market economy. And what's happened is that the public has been led to believe that what is not true. And as a result, there's widespread opposition to these agreements, but reinforced by constant statements made at the highest levels. And it's destructive to our future. We led the world, the United States led the world in the post-World War II period in establishing an international trading regime for the very purpose of preventing conflict and promoting stability. The men and women who led our country then knew that throughout history, trade wars had led to real wars. They knew that for 3 times in the 75 years prior to World War II, Europe had been devastated by major land wars. And with foresight and vision, under American leadership, international institutions were created to promote trade as a means of not only economically lifting people in the societies in their own lives, but of reducing the likelihood of armed conflict. And it's been remarkably successful. Most people today think the world is more dangerous than it's ever been, but that's not so. In the 20th century, 100 million people died in armed conflict in a world in which the population was about 1/3 of what it is today. And we should be proud of what our history of leadership in that area, not denigrating it. Of course we got to do better in improving agreements. Every trade agreement I've been involved with has been better than the last one. Each one we learn from our mistakes, and none of them are perfect. But on balance, they have helped lift our country. We are the dominant world power. We will be for as far in the future as humans can see. They have helped other countries. They have reduced the likelihood of conflict. And I think that we ought to have a national effort to do just what Carla said, to concentrate on helping those who are victims of the technological and trade revolutions through which the world is passing, not beneficiaries. Most of the people in this room, lawyers and others, we have all done very well as a result of this revolution. But it's the people whose jobs were lost because transformation in economies, who don't have the education and skills. And if Carla's program became our national policy, we'd be much better off for it, and we could have a much brighter future for those people.
Judge Griffith, let me ask you a slightly different question. You mentioned earlier, you referred to public servants taking an oath to defend the Constitution. I'd like to ask you about loyalties of public officials. Public officials are in public service. We refer to them as public servants interested in advancing the public interest. We all have taken oaths to defend and protect the Constitution of the United States, in which these rule of law principles are embedded. At the same time, as a political matter, public officials are appointed or elected along party lines. They have loyalties to political parties, to their constituents, to their own ideology. What's the right way for public officials to balance these different interests and loyalties while serving in a public position of responsibility?
That's a really easy question for a judge to answer. A little more difficult for a politically accountable person to answer. But I'll give you the easy answer. So as it turns out, there are 4 steps to becoming a federal judge. First of all, you need to be nominated by the president. Second, you need to be confirmed by the Senate. Third, you then need to be appointed by the president. But the last step, you can't hear a case, you can't get a paycheck, can't put the robe on unless you do the 4th, and that's take the oath. The oath is prescribed by Congress. Congress has written the words of the oath that every judge needs to take. I happen to carry a copy around with me here, and it says in here that I take an oath to be impartial, to be absolutely impartial. And Congress was so serious about it that in the statute, setting forth the words of the oath that every judge needs to take, it ends with the phrase, "So help me God." Mm-hmm. That raises it to a whole new level, right? And I'm certain that every judge does what I do the first day that my law clerks are in chambers, but I give them a copy of my oath, and I tell them their most important responsibility this year is to help me keep the oath because it's a great job, but I don't want to lose my soul over it, right? And so the key is that the Constitution, impartially applied, is your primary loyalty. Again, I say that's easier for judges to do because there's a strong ethic surrounding that. A little more of a challenge for people who are associated with partisan affiliations. As when I was appointed a judge, one of the first things I did upon advice of people I respected, I no longer register by party. You don't have to do that as a judge, but I think most do that. Don't vote in primaries anymore. You just have to see things through a very different lens as a judge.
Senator, all these checks and balances by your counterparts here obviously slow things down, complicate the business of government. And we've struggled with those issues over time in our history, but my question is this still a sound design for us? Does this serve our national interest now in a new, different technological era as much as it did before?
I think the answer is yes, if you view it through the perspective of history. I didn't always look at it that way when I was Senate Majority Leader. When I was elected Senate Majority Leader, I want to follow on the point that Judge Griffith made. The first person I called was Bob Dole. He was then the Republican leader in the Senate. And I went to see him, and I said to him, which is true, you've been here 28 years, and I've only been here a couple of years, so you know a lot more about the Senate than I do, but I do know that if the leaders don't trust each other, jobs that are already extremely difficult become impossible. And so I set forth the simplest standards of decency, fairness, openness, and he was delighted. We shook hands, and to this moment, not once ever has a harsh word passed between Bob Dole and me in public or in private, although we disagreed every day on almost every bill. But we focused our arguments on the merits. We didn't make it personal, and sometimes his view prevailed, sometimes mine prevailed. That's democracy in a diverse society. And I do think that our system works viewed over a very long period, although not often for immediate crises. The Senate is a microcosm of our system. I used to joke that the founders believed that the best way to prevent bad things from happening was to prevent anything from happening.
Well, we're getting good at that.
Yeah, and believe me, the Senate is very good at that. It doesn't take much strength or ingenuity to prevent things. It takes a lot of work to get anything done. So while there will be undoubtedly errors made by omission, the failure to act because of the constraints of our system, over the long run, if you look at it from the perspective of the founders, preserving the sovereignty of the people, preserving individual liberty, promoting the health and welfare of the society as a whole, ours has been a remarkably successful country, even though you can go back and pick out huge, egregious errors that have been made, not only by, quote, bad men and women, but by good and great men and women, proving the point that Jefferson made when the point I quoted earlier, in which I used the word Monroe, I meant Madison, talking about the Constitution. But that's the reality. This remains a great country. Self-criticism is a valuable part of human life, in individual lives and in societies. But like every virtue carried to an extreme, it becomes a vice. And sometimes we are way too self-critical. I spent a lot of time overseas. And when you spend a lot of time overseas, you begin to appreciate our country and to begin to appreciate the broad nature of appeal that America still has to people all over the world. I'll close with just one comment. In Europe recently, a guy got up in the Q&A and kind of gave me the needle that China's overtaking the United States, and he kind of said it with glee in his voice. And I asked him this question: when is the last time, and I'll ask this audience, when is the last time any of you heard of anyone risking his or her life to break into China. That's the answer. And yet millions and millions of people around the world want to come here. And they don't want to come here because we've got the best cruise missiles. They want to come here because they see freedom and opportunity. And our system works to preserve that. We have to keep that in mind and overcome the obstacles. But I think overall, we remain a beacon to the world.
So we've talked about a number of principles that are written principles that are in our Constitution, but there are commentators that make the point that the rule of law is dependent on and is supported by, reinforced by what may be called unwritten rules or traditions or the like. Respect for the courts, that's not written down in the Constitution. Civility, the ability to communicate and compromise. Judge Griffith, let me ask you about these unwritten rules. Are they integral to the rule of law, and are these rules changing?
I think they're absolutely integral, and we can go to the Constitution itself to demonstrate this. If one looks at Article 2 of the Constitution, dealing with the powers of the executive, it's awfully spare. Mm-hmm. It doesn't say a whole lot, and we know why it doesn't say a whole lot, because all of the framers knew who the executive was going to be. It was going to be George Washington, and they had great confidence in his character and his integrity that he would fill in with the unwritten rules about how an executive is to act. And those unwritten rules have survived in our understanding of what the executive is supposed to do and doesn't do. Let's go to in my view, our greatest president, Abraham Lincoln, understood that the precondition for the Constitution, the most fundamental principle behind the Constitution, the deepest principle of the Constitution, is that people need to want to have a union. They want to be part of this. Remember his first inaugural address, the greatest inaugural address ever given. It was the country's falling apart. He relies upon, he calls upon the bonds of affection that our people had to hold us together. Lincoln understood that without those bonds of affection, without the desire to build community, without the desire to have union, the written rules of the Constitution aren't going to mean much. And that was a sad moment because he wasn't able to hold the country together because the bonds of affection weren't there. In his second inaugural, the best second inaugural ever given, as he's trying to reconstruct this country after it's been frayed and fallen apart, what does he resort to again? With malice towards none, with charity towards all. It's the same idea, the bonds of affection. This experiment, and it's succeeded, but it's being tested in new ways now as our population changes in its nature and diversity, as we have new tensions that come upon us. The Constitution will only work if there's a common commitment to make it work, to build community. And what does that entail? That entails recognizing that sometimes you're going to win and sometimes you're going to lose. Another example from history, when the Constitution was ratified, Patrick Henry objected to it. He was an anti-federalist. He was opposed to it. A group of people came to him and asked him to lead a movement against it, against the country, against the Constitution. He said, no. We lost, but we're part of this union. We will join with the union. This is an unwritten rule, but it's absolutely critical to it. You got to want to create community, and that involves the compromise that Ambassador Hills and Senator Mitchell has been talking about. It involves a give and take.
Indeed, there's some that describe the Constitution as a type of covenant among the people coming together to form a nation, and that must endure.
It's the phrase, a more perfect union, right? It's
and Ambassador Hills, what Judge Griffith was just talking about is coming together to solve problems. We seem to be a little less into problem solving than into ideological arguing. I mean, is this a bad habit? Are we not good listeners, good communicators? Is the moderate middle underrepresented? How do you see this?
Well, I think that the senator stated the problem that we have gerrymandered districts and we have a lot of money going into either the red states or the blue states. You know, when I used to walk into a room as Secretary of Housing, there were reds and blues. And if you're trying, and we had 2 big housing bills, to sell it, you talked about the merits. Today, you talk about what you want to hear, not what the policy issues are and what needs to be done. And I think that that's something that we should worry about, because it does peck at the union. You know, we've become much more at the fringes. In the old days, my days, we had a round middle, and those at the fences were few. Now I think that people who study our politics say the big lumps are at the fences and they're fewer in the middle. That's a problem.
I want to take advantage with this group of turning at least briefly to the rule of law internationally. Each of you has had extensive international experience negotiating with countries all over the world, being dropped into some of the most intense conflicts in the world, working with emerging democracies to help establish new institutions. Let me ask how important the rule of law is in that context, and what are the challenges in dealing with countries where it's not accepted, where it's not a shared value? Let me just throw that open to the 3 of you.
I think it is of critical importance, and it's becoming more difficult. First, you have many more countries. When the founders were writing the Constitution, there were a relatively small number of countries. Well, now there are nearly 200. We sit in the Wilson Center. President Wilson's 14 points when he left the U.S. to go to the Versailles Conference after the First World War, talked about the right of peoples to have their own, have self-governance. But I don't think he anticipated the complexity of applying that in real life situations when societies had been mixed, particularly in Eastern Europe, in the Middle East, in parts of Africa. And so the very large number of countries growing steadily makes it much more difficult. And as I mentioned earlier, it is extremely difficult in societies with no history of democracy. Democracy is a demanding system. Everybody knows Churchill's quote is the worst human beings have ever thought up except for anything else that's been tried. And we can see it in our own society. Our own, here we are, 240 years old and a beacon to the world, and we're having a hard time living by our own democratic principles, all the high-minded talk that we've been engaging in here and the difficulties we're having in our own country. So I think it's absolutely critically important. And I think we have to keep at it. I believe, I did not agree with everything President George W. Bush said or did, but he articulated in what I thought was a very persuasive and eloquent way the importance of our advocacy for democracy worldwide, that we don't want to impose our system on others, but we want to make clear our support for those who share our values, because where democracy does well, America does well. And I think it's good for the people that we want to help and encourage, not to force it on them, and good for us.
Ambassador Hills, how do you see this in the context of multinational negotiations with lots of people around a large table?
For 70 years, whether we had a Democratic or a Republican administration, we have fought to have rules that would govern trade, believing that if there were rules, call them laws if you will, that we would have less contention and potential wars. And you know, when we finished World War II, just a handful of nations, 24, created the GATT, the General Agreement on Tariffs and Trade. And then in the early 90s, we began the Uruguay round and finished it by creating the World Trade Organization that brought together then 126 nations. It also upgraded the rules, the laws, and has, I think, made an enormous difference. Today we have 164 nations that members of the World Trade Organization. Now, as the senator said, in his words, trade agreements aren't perfect. I would say trade agreements are about as good as they can get when they're negotiated, but they need to be modernized. And that's true of the World Trade Organization. It needs to be upgraded to deal with the economic issues and contentions that we have today, just as the North American Free Trade Agreement does. Neither agreement is bad, but they didn't deal with some of the issues that are front and center that are captivating us today. And we have the opportunity to do that with both institutions. And both of them have a dispute settlement mechanism, the law. And that has been enormously helpful. You know, it was President Kennedy who said, a rising tide raises all ships. Well, we've gone from 24 to 164, and the global economy is much better off. We've had less contention, and hopefully we can keep moving these ships in the same direction.
Before turning to a final question or two, Judge Griffith, I'd like to ask you about a situation in which countries are trying to establish the rule of law that have not had it before. My experience, they tend to be the most passionate people in the world about the rule of law. But in terms of transitioning, for example, from a court system that's not independent to an independent court system whose judgments and decisions are respected, what kind of obstacles face that type of transition?
Well, it shows, and all this shows, that the rule of law at best is a fragile possibility. And it's, as Senator Mitchell said, democracy is really hard work. There are two things in the American experience that I think people can learn from that have helped our judiciary. One is the nature of the appointment. For federal judges, it's a lifetime appointment, which means there's a significant measure of independence from political pressure. And something even more practical, in our Constitution, you can't reduce the pay of judges if you don't like their decisions. And those two practical little tools have served our country extremely well in terms of creating an independent judiciary. But there's so much more to it than that. There are 1,000 different sources of the civic virtue that needs to go into creating the rule of law. It's a byproduct of civil society, and it just takes an enormous amount of work and heavy lifting. And the problem with it is it's not natural, right? The rule of law doesn't seem to be natural. The natural order seems to be might makes right. And what we're trying to do here, what our framers tried to do and what we're trying to carry on, is it goes against the grain of history, and it's hard work.
If I could just add a comment. We have to recognize just how difficult it is for other countries by looking at our own history. We talk about what a great place this is, and we talk about the difficulty of politics. But in fact, politics has always been very rough in our country. Rough and tumble, a lot of invective. the presidential campaign of 1800.
Right.
That Jefferson was the challenger and Adams the incumbent was as vituperative as any that has occurred in our history. The difference was, of course, they didn't have the ubiquity and power of electronic communications, and the harsh words that were written and spoken at that time didn't have the carry and the force that it does now. But you look at all the tremendous mistakes we made. Our Constitution, which we rightly revere, condoned slavery. The only people who could vote were adult white men who owned property. It took a bloody civil war then took 70 more years to give women the right to vote. Can you believe it, Carla? 70 years, it was a huge political struggle to get women the right to vote. So we've come a long way, made terrible, terrible judgments in some cases, but we shouldn't be overly critical of others who struggle with the same issues and who lack the same advantages that we had, insulated by two great oceans, a massive continent filled with natural resources, people wanting to come here. Impatience can be a virtue, but also it can be difficult. And in making the transition to democracy, think about this fact. In France, it took a half century from the revolution before they established their republic. In Britain, 200 years and so many wars, you can't keep track of all of them. There aren't 6 historians in Oxford who can trace all of the winding road the British found to a constitutional democracy. So, or a constitutional monarchy, I should say, an unwritten constitution. So we should advocate, be strong, but also be understanding of the difficulties that our system creates.
Let me close with this question. I think it's clear from the discussion we've had that the rule of law is not something we can take for granted, that it can be put at risk. So the question I'd like to ask is, given that, what are the obligations and responsibilities of those in government who hold senior positions and all the rest of us who are stakeholders in this process?
Well, here's some bad news. It's really hard work. It's really, really hard work. It's hard work to understand the Constitution. You know, it's fashionable in Washington to carry your pocket Constitution around, and most of us do. It's not an easy document to understand. I cheer the use of it in political discourse in the last 10 years or so, but it's not an easy document to understand. It needs to be studied at a serious level. So it's hard work. The second one is, just to concur with what's been said before, there needs to be a commitment to union and civility. There needs to be a commitment to the other, to listen to them, to hear them, and then to want to live with them. And that works both ways. And those are two really hard tasks that cut against the grain of human nature. But I think it takes nothing less than a commitment to those two civic virtues to be able to realize this fragile possibility.
Well, I think we all have an obligation. If we focus on the United States, every American has an obligation to try to inform their fellows. The think tanks that exist, the chambers of commerce that exist, our elected politicians should, to the extent that they can be pushed to explain the value of rule of law and our system, because the rule of law is what holds the system together, keeps it from being corrupt. And it just sitting by the wayside and worrying about how things have changed won't suffice. We really have to get out and explain why we think this is worthy. So you're developing messages that can be shared. I compliment you for it.
Well, I think we're fortunate to be Americans, citizens of what I still think is freest and most open society in the world, but we have to work harder at preserving civility. I think you mentioned the unwritten rules that are so important in an open democratic society. And I think we need that from the highest levels of our government. We now have a society that celebrates celebrities, and politics and entertainment have become entwined. And I think that it's very important that each generation of Americans be reminded of our history, of their obligations as citizens. And that means, I think, much more emphasis on improving our system of education and making opportunity available to all.
You've been generous with your time, but let's quickly do a couple of questions from the audience as we can. And let me start with one that's quite specific and relates to the separation of powers. And the question is, do you think executive orders, which are substantive, are unconstitutional lawmaking? Do they infringe on the
Have to ask the
legislature?
All eyes are on the judge.
Yeah.
No, I don't. Is that enough? No, there's a long history of, I mean, it depends on the nature of the executive order, right? But there's a long, there have been executive orders since the founding of the Republic. The president has a right to direct the executive branch and how they'll act in things. And so there's no problem with that. Now, the particular nature of the executive order could trench on congressional powers, could violate individual rights, and that's different. But to categorically say executive powers are unconstitutional, I don't think I'm getting in trouble by saying that's not the case.
Well, let's go to question 2. Countries throughout history have had volatile leaders who have seemed benign at first, but have then become domineering and harmful. What keeps you hopeful, or better yet, confident, that our country's checks and balances will remain effective over the next several years? You may answer that question without naming names.
Well, of course, starting at the top, we have term limits. So no president can serve for more than 8 years. Could do a lot of damage in that time, but I don't think can completely sever or undermine the institutions in our society. And I think our institutions remain strong. I think that's being demonstrated now and will be in the future.
Our last question is focused on the judiciary with the point that the strong do not always win. As a proxy for a healthy rule of law-based system, how is our judicial system doing, particularly in light of the disparity in the quality of legal counsel and access to the legal system available to those people and corporations with money and those without?
I'm generally optimistic. I mean, reform can always be done. There's serious discussion on the Hill for a number of years about criminal justice reform and civil justice reform. That it can always get better. But fundamentally, it's quite remarkable to see the process as it plays out, at least in an appeals court. Every case is considered on its merits. You spend a lot of time trying to figure out what the right result is according to the law, and that's done without regard to the means that that a litigant can bring to the table. So I'm generally optimistic, and I think, maybe I'm biased here, but I think the American judiciary has done extremely well. And continues to do so.
The last
I
question.
just want to say all human beings and all human institutions are imperfect. No one of us is free of error. If you compare the American system to perfection, it necessarily fails. If you compare the American judicial system to almost any other on the face of the earth or in all of human history, we do very well.
Thank you. The last question is prescient, and I will answer it. There has been no discussion of the importance of an independent press. Where does this stand in the hierarchy of the rule of law? The answer to this question is come to our next program, which will address exactly this issue. It will be on June the 7th at the National Archives. And with that, let me ask you to join me in thanking this wonderful panel.